Hello friends, Namaskaram. Myself is Dr.Jinesh Soni. I am an advocate and a corporate lawyer. Today we will discuss Section 13, Subclause 1, Subclause B of PCA. Please maintain the proper notebook and maintain the recorded information which I am going to provide you on practical basis. First of all, we will note down the practical problem. The problem is that there is common queries from the side of public servants that we are prosecuted as per Section 7 and Section 13(1)(b) of PCA, but we have not committed the offence under Section 13 subclause 1 subclause B of PCA. But despite of that, we are prosecuted on ground that we demanded and accepted the undue advantage. That is basically unjust enrichment, and that's why we are liable. As per the legal position, when demanding and accepting undue advantage is an offence as per Section 7, then it would be unjustified to apply Section 13 subclause 1 subclause B of PCA. Please enlighten on the subject and explain. The said problem is too much common in state of Haryana, Gujarat and Madhya Pradesh. So basically we have to discuss the entire things not only in the theoretical perspective but also in the practical perspective as well. For this we have to study Section 13 subclause 1 subclause B of PC Act at inception. The said section inter alia says that a public servant is said to commit the offence of criminal misconduct. So basically Section 13 of PC Act is concerned with the offence of criminal misconduct. Please be noted. And it is applicable only on the public servant. So if you are a private person and inter alia prosecuted in a case under PC Act, in that scenario, you may challenge the proceeding on ground that Section 13 would not be applicable on you. So, at the inception, it is quite clear that the public servant could be prosecuted as per Section 13 of PC Act for criminal misconduct. Clause number A is concerned with misappropriation, and clause number B is concerned with intentional enrichment. And intention is the essential element of Section 13, subclause 1, subclause B of PCA. So, if the public servant intentionally enriches himself during the period of his office illegally, which is called illicitly, in that scenario, he would be liable to be prosecuted as per Section 13, subclause 1, subclause B of PCA. Please be noted. So, by the virtue of clause B, it is quite clear to us that for the application of Section 13, subclause 1, subclause B of PCA, there is a requirement of intention. Number 2, there must be enrichment. Number 3, it must be during the period of the office of concerned public servant, and apart from that, the act must be illegal or must be in violation of law, that is called illicit. Apart from that, there are two explanations attached to Section 13, subclause 1, subclause B. First one says that a person shall be presumed to have intentional enrichment if he or any person on his behalf. So, along with the public servant, his wife or his children might be prosecuted if there are sufficient evidences on record that the inter alia helped the concerned public servant to have the accumulation of the asset in unjustified way. So basically, the concerned explanation is inter alia concerned with the presumption. It says that a person shall be presumed to have intentionally enriched himself illicitly if he or any person on his behalf, means either the concerned public servant himself or any person on his behalf, is in possession of or has at any time during the period of his office being in possession of pecuniary resources or property. So the consent offense is related to the tenure of office of the concerned public servant. If during that tenure the concerned public servant or any person on his behalf is in possession of pecuniary resources or property that is disproportionate to his known source of income. In that scenario, the concerned public servant or the concerned person aiding him would be liable, but that concerned person would be prosecuted as per section 12 of PCA. But the key point is that there must not be any satisfactorily accounting for the same. And if the concerned public servant is having the satisfactorily accounts for the same, in that scenario, section 13, subclause 1, subclause B would not be applicable. For example, during the trap proceeding and house search, it is found that the concerned public servant is in possession of assets which is disproportionate to his known source of income. But he submits that the entire assets belongs to his wife and she is a businessman and having a good income tax return. In that scenario, if the concerned public servant is having the proper justification, section 13(1)(b) of PCA would not be applicable. For this, you may peruse the important judgment of Honorable Supreme Court dated 4th of December 2024. And apart from that, the expression known source of income means the income received from any lawful sources, means income from salary only. So we could say that if with section 7, section 13 subclause 1 subclause B of PC Act is going to be inserted, then it is illegal. Because section 13 subclause 1 subclause B is concerned with unjustified enrichment. And apart from that, it is indicating that if the concerned public servant is having the assets which is disproportionate to his known source of income, in that scenario he would be liable. But section 7 of PC Act inter alia incorporates protocol regarding the prosecution and punishment of public servant who inter alia demand and accept the undue advantage to perform or cause performance, including forbearance of the concerned public duty either improperly or dishonestly. Otherwise, he would not be liable. So the key point is that whenever the concerned public servant is charged with allegations that for the work of complainant he demanded and accepted or merely demanded the alleged amount, that is bribe, in that scenario the public servant would be liable for section 7 of PC Act. He could not be prosecuted for section 13 subclause 1 subclause B of PC Act. So if you are having the said prosecution, you may argue the discharge and inter alia submits to the concerned court that the insertion of section 13 subclause 1 subclause B of PC Act ipso facto illegal. The reason is that it is applicable only when I am having the properties which is disproportionate to the known source of income. But when there is the allegation on file that I demanded or accepted or both, in that scenario only section 7 of PCA would be applicable. By having the said argument, you may easily hit section 13 subclause 1 subclause B of PCA and could be succeeded. And apart from that, I am having the reference of one of the most important judgment of Honorable MP High Court, wherein it is observed that in the trap case, when there is no efficient recoveries from the concerned accused, section 13 subclause 1 subclause B of PC Act could not be applicable. So whenever there are two accused, one demanded and other accepted, the person, means a public servant who demanded, can be charged with section 7, but he cannot be charged with section 13 subclause 1 subclause B of PC Act. So I think that I inter alia cause all of you to understand the basis of section 13 subclause 1 subclause B of PC Act. If you are having any query, you may write in the comment box. I will try my best to answer the same. See you in the next video. Till then, Jai Hind, Jai Bharat.